Hello, everybody. Thank you so much for joining us today. My name is Juan Carlos Brando, and for me, it's a pleasure to be here in this show with one of the attorneys in the law firm of Margaret Wong and Associates. Today, we're going to be talking with one of the expert attorneys in the law firm, which is Attorney Kwasi Bediako. I've been able to talk to him and to host the show with him several times, so I think he may not need introduction. So, however, he's one of the experts in cancellations of removal, asylums, waivers, well, many other areas of the immigration law, but this is like the specialty that he's working. So, thank you so much, Attorney Kwasi. How are you doing today?
Thank you, Juan. I am doing excellent. How are you?
I'm doing great. I'm doing good. Despite of the hurricane that is coming by, uh, still safe in here.
That's
Still
good.
safe. Later on, I don't know what's gonna happen, but probably overnight it's gonna be hitting here the city of Atlanta. I've never seen something like that here in Atlanta with over 100 miles per hour winds. So I don't know what's gonna what that's gonna be like, but hopefully it's not gonna be really too bad. So thank you so much, Attorney Kwasi. And well, I would like to start talking about the extreme hardship, because that's one of the aspects that people need to learn before they can file a waiver, if before they can file a 42B or cancellation of removal. So what would be mainly the difference between suffering and extreme suffering, or hardship and extreme hardship?
Okay. Thank you, Juan, for this question, and I think that's a really good question. So, usually, to be able to prove extreme hardship, you would do a totality of the circumstances thing. Okay, so let's say I'll use an example here. So let's say there's A and B. Okay, both of them are immigrants, right? A maybe has diabetes, but that's about it. Uh, A is married to an illegal alien who's looking to get a waiver for the 2B cancellation. But then all A has is diabetes, right? And then there's B. B has what we call terminal cancer. Okay. A and B are both sick, right? They both have spouses who are looking to get waivers and are using A and B as, let's say, qualifying relatives. However, if let's say A is from Honduras, okay, and B is also from Honduras, if you go back to Honduras, you probably will have access to diabetic medication, right? In a case like that, even though it may be difficult, because when you go back, you probably won't be able to afford it in Honduras as much as you would here in the USA. A would suffer because they would probably have to work a little bit more to be able to afford diabetic medication. But it is unlikely that A would lose their life because they wouldn't have any access to diabetic medication, right? And then B, on the other hand, probably has some kind of terminal cancer, is on some kind of dialysis. And let's say, this is just an example, the whole of Honduras, there's only one dialysis machine. And B has to travel, let's say, hours and hours to have access to it if he should go back to Honduras, right? In this case, if A and B go back to Honduras, A would suffer in the sense that he would have a hard time getting diabetic medication, albeit, he might have to work maybe uh, 3 weeks to be able to afford it instead of maybe a couple of days here in the US that would allow him to afford it. B, on the other hand, will suffer extreme hardship in the sense that if he should go back, one, he's likely going to die. He would have no access to the necessary medical care. Okay, even if B would have access to it, B would have to travel miles and hours to have access to that medical care for that, let's say dialysis or cancer or whatever. So in B's case, it is likely that there would be extreme hardship if he does go back. So extreme hardship ends up being hardship that is beyond a regular hardship, beyond something that is expected. Let's say if your partner gets deported, that hardship would be extreme in the sense that it would be beyond what you expect a regular person to face if they should go back to Honduras. I don't know if that example does paint the picture.
Yeah,
Hopefully
that's
it
very
does.
good. Yeah, that's very a very good example. Because here in Georgia, maybe 4 years ago, when Trump was president, one judge said that, for example, Down syndrome was not an extreme hardship for a cancellation of removal. So, is that something that becomes doctrine or a rule in the US, or is just the opinion of that judge and that can change?
So one, it depends on the court. So it depends. It's going to be a typical lawyer answer. It depends. Okay, if the Supreme Court says that, it becomes law. Okay, but if a judge in, let's say, a circuit, let's say the Fifth Circuit or the Sixth Circuit says that, okay, you could appeal to a higher court. However, if you don't appeal it and it remains, then until a new decision comes, it could change. But until the new decision comes, that will be the law in that circuit and that in the jurisdictions that the circuit covers. So, but for most circuits, thankfully, Down syndrome is one of those things they would consider extreme hardship. It wouldn't be just one factor, in itself would not be enough. But usually, under the totality of the circumstances, they look at the Down syndrome, the cost of taking care of the kid, having access to health insurance, specific needs of the kid. The kid's probably American, grew up here, and all of that. Then when they consider all those circumstances, the court is likely to find that Down syndrome would cause extreme hardship if the kid has to go back to their country. So it usually depends on the totality of the circumstances. But just having one Down syndrome, some courts will consider that extreme hardship. Unfortunately, some other courts will deem it not to be extreme hardship. So it depends on the circuit in which you are.
Okay, thank you so much. Yeah, I know that was a very criticized decision on that judge. I think that went to an appeal, but I don't know what happened with the appeal because I didn't follow the case anymore.
Right.
But at that moment, that was something that scandalized a lot of attorneys and activists here in the state of Georgia. But let's go ahead and start with the first question. It says, "Hi, my sister-in-law came on a humanitarian parole. She came a year ago. When it expires, will she need to leave the US? Is it convenient for her to file asylum? Thank you."
Thank you, Juan. And once again, that's a good question. First of all, I'm going to say using the word is it convenient for her to file an asylum? You need to file an asylum when you need an asylum, when you need protection from some kind of persecution, not when it is convenient, first of all. And then, secondly, usually you have to file asylum within 1 year. Okay, I sent your sister-in-law came to the U.S. 1 year ago. If she came to the U.S. to seek asylum, then she should have applied for asylum before that 1 year of her entry. Okay, before she gets to 1 year of her entry. If it expires, so when it expires, do you need to leave the U.S.? Technically, yes. Okay, because when you're granted parole, you're allowed into the U.S. for a limited reason. Okay, and if um, it is expiring, they expect you to leave because they assume the limited purpose for which you were allowed into the U.S. is over. So now you have to leave. Do people leave? Usually not. Okay, but technically they have an expiry date on it because it's allowing you to come to the U.S. temporarily, do what you have to do, and then leave the U.S. Okay, is it convenient? It's going to depend on your sister's circumstances. Uh, does she have a fear of persecution, or does she have some kind of past persecution? Is she genuinely afraid to go back, or is she just seeking asylum because she wants to be in the US and wants to work in the US? All those are factors that you would consider in deciding whether it is convenient, whether it is safe, whether it is right for her to apply for asylum. Okay, and once again, I will reiterate: you don't apply for asylum because it is convenient. You apply for it because you need it. You have genuine fear of persecution if you should return to your home country. So don't ever say, is it convenient? You have to look at the circumstance and see, will she be safe if she has to go back, and all of that. And then you use that to decide whether to seek asylum. And once again, always, always, always apply for the asylum within 1 year of entry into the US. There are exceptions to that 1 year, basically changing country conditions or extraordinary circumstances. If any of them applies to your sister, you would have to explain to the USCIS why she didn't apply within 1 year. So let's say she came, uh, she got really, really sick. Okay, really, really sick. She's been bedridden for the last couple months, and she had planned to file it, but then all of a sudden she couldn't because she's been sick. That's an extreme, extraordinary circumstance that may be an excuse that would excuse you from filing within the 1 year. But ideally, she has to leave when the parole expires unless she applies for asylum. She only applies for asylum if she is afraid of persecution, that she has faced some past persecution or is likely to face future persecution. However, not because it is convenient for her to allow her to stay in the US.
Yes, this person is adding that his brother has a pending asylum. Can he benefit here somehow?
If I understand the question correctly, is there any way he can help her? The answer is no. Okay. For asylum, it's limited to spouses and children under 21. Okay. So let's say your brother can only help or can only include his spouse, which is his wife, and then his kids under 21. Okay. You cannot include your brother or your sister in your asylum application.
Okay, yeah, I think he's talking about um, his sister-in-law, who is his brother's wife.
Right. All right.
So yeah, so the brother has an asylum pending. She is here on a humanitarian parole. So could he benefit here somehow?
In that instance, yes. I apologize because I read it as his sister. Okay, your sister-in-law, which is your brother's spouse, yes, she could be included on the asylum. You could revise it and then include on the asylum petition.
Okay, thank you very much. We have an interesting question here. It says, "What is the success rate for VAWA and T visa?"
So, unfortunately, success rate is a very open-ended question. Okay, so there are a few things for every application that you file with the U visa. There are some requirements. Okay, VAWA depend on the basis. Are you a spouse of a U.S. citizen or permanent resident that has been victim of violence? Um, you have to meet the requirements. So they state one, you have to be a person of good moral character. If you're still married to the person has to be a U.S. citizen or LPR, which is a legal permanent resident. Um, you're gonna have to show that you suffer some kind of abuse at the hands of your spouse, who is a U.S. citizen or LPR. Okay, if you can meet these, if you can prove it, each of these factors, then your likelihood of being successful on the VAWA is high. Okay, assuming you've divorced the person, if you file it within 2 years of the divorce, then you will be okay. So it's basically factors that you have to prove. You have to prove that one, you got into the marriage legitimately. It's a bona fide marriage. You love the person. You didn't do it because you wanted to apply for immigration benefits. So you have to show the marriage is bona fide. You can show this. You have kids. You've been together for years. You've been married for years. Friends and family and every. You have pictures. You have property in your name, joint financial responsibility, and all of that stuff. If you have all of that, then there's a very likelihood that your VAWA will be successful. Okay. T visas, we do a lot of T visas, you do a lot of VAWAs. We have a high success rate, but each is case dependent. Okay, for a T visa, you have to prove that you were a victim of trafficking. Okay, and usually you have to report to the police or law enforcement, have them investigate a trafficking incident. If you did not report it to the police, there's a minor exception that allows you, which is the age or the trauma exception. Age exception is where if you're under 18, when the incident happened, and because you were young, you never really went to see the police. Then the trauma exception is if you were too traumatized to go see the police, you would have to prove this trauma. Both of them are not easy to prove. However, if you can show that you were trafficked, so basically some people brought you to the US, forced you into some kind of work or seized your passport, threatened you, forced you to pay money, and all of that. Two, you cooperated with law enforcement, okay? Or if you did not cooperate, then you are covered under the age exception or the trauma exception. And then three, you would face extreme hardship if you should go back to your home country. If you can prove all of these, you are likely to be successful at TVs. So back to your question, what is the success rate? Uh, it depends on the fact that you're able to prove. If you're able to meet all the requirements, then you would have a high success rate. If you cannot meet all requirements, then it's a lot more difficult. However, each case will be independent. We would have to look at the case, analyze it. Uh, all in, when we do cases here, we do them to win. So you are likely to be successful if you contact our office. It's not 100% guaranteed, but reach out to us. We can review your file, see your case, see if you're eligible for VAWA or T visa.
Okay, thank you very much, Attorney Kwasi. Don't forget the phone number is 216-279-3984. 216-279-3984 is the phone number that you need to call in order to talk to one of the attorneys in the law firm of Margaret W. Wong and Associates. They have offices in Atlanta, Chicago, Cleveland, Columbus, New York, Nashville, and Raleigh, North Carolina. And there is a website that you can visit and see more information. The website is www.imwong.com. And for more information or to make an appointment, you can call the number 216-279-3984, 216-279-3984. Next question. Hi, I married a U.S. citizen 2 years ago. I entered once and was kicked out the next day to Mexico. So I tried again and made it. With the parole in place program, can I get my status? I think
Oh,
it's the Keep Families Together
right.
program.
Okay. So, can I submit it? All right. So, can you get your status? As of now, unfortunately, we don't know what's going on with the parole in place program. I believe if you're talking about the new Biden parole program, because there is parole in place for military families, but that's separate. So can you get it? It depends. Okay, we are waiting. As of now, they've frozen processing of all parole in place programs. So when you file it, you're going to get a receipt. You will get to be able to do your fingerprints. However, as of now, they are not approving any cases. If they do approve it, okay, that means then you would have a legal entry. And there is a likelihood that you'll be able to get your status, be able to file a 485 and adjust status here in the US. The fact that you came and you got kicked out doesn't really change anything because you were here for only one day, then you got kicked out. Okay, unless when you were expeditiously removed, if it's just turnaround thing sent you out, we would have to look at the paperwork. But if it's just that, then the parole should be able to forgive you for any expeditious removal and reentry issues. You should be fine. But as of now, we don't know what's going to happen with the PIP cases. Hopefully, they'll keep processing it and eventually start approving them, and you should be fine. We would have to look at your paperwork, see if you were expeditiously removed, because if so, then you probably would also need a 212. Parole only forgives illegal entry. So basically, if you have an entry without inspection, if you came in across the border, you weren't paroled and they didn't admit you, to be able to apply for get the green card, you have to be inspected and admitted. Okay, if you cross the border and you come inside, then you've not been inspected and admitted. So that's where the parole thing will forgive you. However, if you were expeditiously removed, you're going to need a 212 to forgive you for coming back after being removed. Okay, so in your case, we would have to look at your paperwork, see what kind of removal that you had. If it's kind of expedited removal, then you're going to need a waiver, a 212 waiver to waive you coming back, re-entering the U.S. illegally after being removed.
Okay, thank you so much, Attorney Kwasi. And well, we have several questions coming in, but the next one is very similar to the last one we had, and it says, "Hi, I have an I-130 approved, filed a 601 and a 212 waiver, and waiting for approval. When I leave the U.S. for the consular interview, what are the chances of not coming back? I have a removal order but never left the U.S."
All right. Thanks. Thank you for this question. It's a good question, and congrats on your I-130 being approved. Okay. Right. Once these are approved, I would say try to go back to immigration court, try to reopen it, and take care and get that removal order removed, and then leave the country. Every consulate is different. Okay. If you go and you don't have any other issues with immigration, you don't have any criminal records, you don't have any other thing that will probably buy you, you're likely to be able to come back. It may take some time. It may take months, maybe years, but you will come back. However, if you have a removal order and you never left the country, if you leave, then it will become executed. So before you leave, try to get a lawyer, go back into court, see if you can reopen and terminate that proceedings because now you're eligible for adjustment of status based on your I-130 being approved. Make sure you take care of that before you leave the country if you have to leave. Okay. Chances of you coming back, it's gonna depend on different factors. Hopefully, you don't have any other issues besides that removal order. Um, and the fact that you're seeking a 601A, hopefully you don't have any other issues besides that. But try to get that removal order reopened, terminated before you leave the country if you have to leave the country.
Okay, thank you so much. And we have another interesting question. Don't forget the phone number is 216-279-3984. 216-279-3984. Attorneys in the law firm of Margaret W. Wong and Associates, and offices in 7 cities: Atlanta, Chicago, Cleveland, Columbus, New York, and Nashville and Raleigh, North Carolina. And the phone number is just one, is 216-279-3984. They will answer your call in English, Spanish, uh, Vietnamese, Philippines, um, Hindi, Gujarati, uh, well, Singaporean. Well, it's a lot of languages spoken in the law firm, and French, Italian. Well, it's really good to have so many people. Portuguese. We have our friend Matt who speaks Portuguese, so it's always good to have so many languages spoken in the law firm. I think it's maybe 35 languages or 37 languages that are spoken in the law firm. Also Russian as well. Russian, Albanian. Well, there are many languages that are spoken in the law firm. Okay, so the next question is, I have TPS. I would like to travel overseas, but I don't have a passport because my country doesn't have an embassy in the US. I would need to go to Canada or Mexico to do the tramitation of my passport. Can I travel and come back with a travel document?
So usually it depends. So if you are getting on a plane, right? Uh, most places, uh, most most airlines will require you to have a passport, a valid passport for you to be able to come back. You will probably have issues. Try to get the passport. Unfortunately, if you cannot get the passport, you will have to figure out a way to get the passport before you leave to be safe. Okay, if you're driving by road, uh, it's gonna be a 50-50 thing. It's probably risky to do that. Uh, because if you're driving by road on the border, they wouldn't generally require you to have a passport like the way airlines will. However, it's a 50-50 thing. It's very likely that when you get back to the border, you're going to have an issue because you wouldn't have a valid kind of ID from your home country, even though you would be able to show your TPS, and that might be risky. Try your best to get a passport if you can. If you can wait it out, get the passport, and then you travel, that would help. Okay.
Okay, thank you so much, Attorney Kwasi, for this answer. Yeah, this is a very common question because some countries don't have embassy in the US, so they need to go overseas and try to come back. But yeah, what happens if you need to do the tramitation of your passport, and then you get stuck and you cannot come back to the US? That would be a problem. This person says, I was deported in 2007. Can I file for any kind of work or student visa? I never went back.
So it depends. Okay. Yes, you can apply for anything at any time. Are you gonna get it though? That's different. Okay. It's been more than 10 years since you left. Ideally, you want an immigration attorney to review your paperwork, see the basis, what's in that paperwork, what was the basis for the deportation. Okay, what happened? Uh, we have to see that the reason why you were deported, and then we can further advise. However, you can apply. You can apply for a student visa. Getting it is a different matter on its own.
Okay, thank you very much, Attorney Kwasi. Don't forget the phone number is 216-279-3984. This next person says, my husband is a retired veteran of the aviation in the United States. He's very sick. I am from Mexico. He becomes violent sometimes because he's very sick, but he never filed documents for me. And I would like to know if I could apply for VAWA or U visa because when he becomes violent, he has even pointed me with a gun, and I never filed something. And I called the police a couple of times, but I don't want to send him to jail. I just know that he has a PTSD.
Okay, thank you. Thank you for that question, one. So, can you apply for VAWA or U visa? Yes. Short answer is yes. Okay, and this goes back to the VAWA thing that we talked about. There are requirements for the VAWA. Uh, I believe your husband is a U.S. citizen. You've been married to him for years. It's a bona fide marriage. You've been a victim of abuse. He's pointing guns and all that at you. You can apply for VAWA. Okay. For U visa, on the other hand, it requires you to report to the police, cooperate with the police, and then get a certification from the police to be able to apply. VAWA, on the other hand, you don't need that police certification. Having police reports of you being abused is great. It helps the case. So with VAWA, you can apply for it without even you cooperating with the police, as long as you can prove that you've been abused, you've been a victim of violence. For the U visa, one, you should have reported it to the police. If you have, you're going to need that police department to sign the certification, which is the form I-918B. However, you saying you didn't want him to go to jail, if that's in a report, that might mean you didn't cooperate with law enforcement, because one of the requirements of a U visa is that you cooperate with law enforcement, which means you do everything in your power to make sure the assailant or the suspect is persecuted. Okay. However, if the police comes and then you tell them, hey, I want to report this, but I don't want to persecute it because I don't want my husband to go to jail, then you will become disqualified from pursuing a U visa, because technically that's considered not cooperating with law enforcement. If the person has done a crime, USCIS expects the police to punish them. So if you tell the police not to punish them, then you are not cooperating, and so unfortunately, that will disqualify you from applying for a U visa. Okay. However, if you never told the police that I don't want him to go to jail, and you just think that you don't want him to go to jail, however, you report it to the police, then you may still be able to apply for the U visa. Okay. So for VAWA, yes. For U visa, it depends on what's in the police report. We have to see the police report and see what you said to the police. If it's in there that I don't want my husband to go to jail, I really love him, then you didn't cooperate with law enforcement, and then you would not be eligible for U visa. I hope that answers the question.
Okay, thank you very much, Attorney Kwasi. And yeah, we are. Our time is up for today. So thank you very much for all of your answers, for sharing your knowledge, and hopefully we'll see you in a couple of weeks, or the next time that we have you in the studio to answer the questions. Thank you so much.
It was nice seeing you, Juan. Take care.
Thank you so much. Likewise. And don't forget, the phone number is 216-279-3984. 216-279-3984. Attorneys in the law firm of Margaret W. Wong, with over 47 years of experience working in the immigration field and helping thousands of immigrants every single year. Thank you so much. Have a good day. Have a good lunch, and see you next time. Thank you.